While form interrogatories are useful for asking a number of common questions that arise in civil litigation, oftentimes you will need to ask more specific questions to your case. This is where special interrogatories come in. They can be used to ask any sort of who, what, where, why, how, or when question that you can imagine. Unlike form interrogatories, there is no form for them, and instead they are hand-drafted on 28-line pleading paper. Because special interrogatories are counted in all kinds of cases, they cannot have any subparts, and while drafting them you should draft them very carefully to avoid any sort of ambiguity or other problem with them, as they are likely to be very carefully scrutinized by opposing counsel. Because there is no standard form, there are many different types of templates that can be used for special interrogatories, and each law office and self-represented litigant typically has their own. The sample that is provided with this presentation is but one of many, all of which are adequate. In the upper left-hand side of the template, change Paul Sample and the address and phone number to your name, address, and phone number that you are using in the case, and defendant in pro per should be left as defendant in pro per if you're the defendant, or changed to plaintiff in pro per if you're the plaintiff. The name of the court remains on line 8, and then input the names of the plaintiff and the defendant in place of Acme Inc. and Paul Sample, respectively. Replace the case number with your case number, and then change the title of the document to defendant or plaintiff, whoever you are, your names, special interrogatories to plaintiff or defendant, whoever the responding party is, their names, set number 1. Below that, under propounding party, write your name. Responding party is the name of the party you wish to answer. Like any other type of discovery, this is the name of a plaintiff or a defendant, not an individual witness or the attorney for the other side, unless any of these persons are specifically identified as plaintiffs or defendants in the lawsuit. And then you begin with set number 1. Subsequent sets to that party would be set 2, 3, and so on. On line 18 of the template, where it says to plaintiff Acme Inc. and to its attorney, change that to plaintiff or defendant, whoever the responding party is, their names, and to his, her, or its attorney. On the next line, defendant Paul Sample should be changed to plaintiff or defendant your names. Requests that plaintiff or defendant their names respond to the following interrogatories. This step is very important. One time, a person sent out a beautiful set of interrogatories, and the response that he received back was that the responding party objects on the ground that Paul Sample is not a party to the case, and therefore lacks standing to propound interrogatories, because on line 19 he had accidentally left defendant Paul Sample instead of placing his name. The remainder of this page is simply instructions to the responding side. On the next page there is a section for you to write definitions. Any word that appears in all capital letters inside of your interrogatories has its own special definition that you set. This is useful if you are going to refer to a single event or a single item repeatedly, and that the explanation or description of this event or item is substantially longer. So for example, if you were dealing with a piece of land and that land had a legal description on a deed, you could write that legal description every time that you referred to it, or you could simply define land in all capital letters to mean that legal description, so that when you write your interrogatories, you would incorporate that legal description simply by referring to land in all capital letters. In the sample, we have one definition for accident, which should be changed out as it is unlikely to be relevant to your case. One recommendation that I might make is that if any of the definitions from the form interrogatories, such as incident, you or anyone acting on your behalf, document, etc., seems useful for you, consider copying that definition and using that within your special interrogatories. After the definition section, you would begin with interrogatory number 1, then interrogatory number 2, 3, etc., through however many that you have, and behind each one you would simply have any sort of who, what, where, why, how, or when question, and typically why is not going to be relevant. I wish I had some specific advice for you when drafting these questions. However, what you are asking will depend very much on the specifics of your case. A few suggestions that I might make, however, is that you should be sure that each question you are asking is relevant to establishing a point that you need to establish in your case or disproving a point that the other side needs to establish. Likewise, you should be very careful on limiting the scope of the question. Remember the fundamental rule that any question in discovery must be reasonably calculated to lead to the discovery of relevant admissible evidence. One of the most common objections that you may receive in response to your special interrogatories is that the request is vague or ambiguous, or unduly burdensome, or not reasonably calculated to lead to the discovery of relevant admissible evidence. In these instances, the most likely culprit is the scope of the question. If, for example, your case is dealing with a bank account or credit card account, you would not wish to have an interrogatory which would ask, "On what dates did you send statements?" Because this would be objectionable because it is not sure what account you are referring to whom they are sending statements to, and for what dates. Instead, you would wish to ask a more specific interrogatory such as, "State any dates upon which you or anyone acting on your behalf sent account statements regarding the account that is the subject of this lawsuit to the defendant in this case on or after," and then a particular date that you specify. By doing this, you have limited it to a particular account, a particular range of dates, a particular set of things that you are asking about, and it cannot be argued that you are referring to some other person's account. Other than this, one of the best ways to know what type of interrogatories to ask is to search through practice guides and also look through interrogatories that have been prepared by others so that you can emulate the format and limiting of the scope of the interrogatories that you are asking to give you a higher chance of success. Once you are done asking each of the questions that you wish to ask, you would simply print your name and sign at the end of the document. Have the special interrogatory served on the opposing counsel by someone over the age of 18 who is not a party to the case, keeping the original and having the copy served. And if it is served by mail, having a copy of the proof of service served along with it, keeping the original for your records.